All right, court calls cause number 2260, Happy Hollow Ranch. Ask for appearances for the record. Will be doing this call.
Thank you, Your Honor. Dottie Vidal on behalf of Happy Hollow Ranch Limited Partnership, Howley Family Trust, and on behalf of Chuck and Nancy Howley, Robin Howley Pavey on behalf of Nancy, next friend on behalf of Chuck and Nancy Howley.
Peter King. I'm here for Dottie Vidal and your reporter and Don.
Thanks, sir. And you said it's Peter King?
Yes, hey,
Thank you, sir. Mr. McCoy?
Jason McCoy here for Brandon Howley and Lownjager LLC. In this case.
Mr. Elliott?
Jewel Elliott here is Loudon for Chuck and Nancy Howley.
Mr. Beckman?
Justin Beckman here for Scott Howley and Robin Bailey.
Thank you, sir. All right, we have anyone else? Lead counsel?
Oh, sorry, co-counsel, Christopher Snyder, co-counsel, Jason McCoy.
Snyder?
Snyder, SNYDER.
Thanks. All right, so on the docket today is Mr. McCoy's Rule 12 motion. Is that correct?
It's on the docket, yes, Your Honor.
We want to proceed with that first.
Well, I have an objection to proceeding with that. Without waiving that objection, I'll agree to do that.
Okay, what's your objection?
Well, there's several objections, Your Honor. The first objection is that Rule 12 requires 10 days. It requires citation and 10 days notice of the hearing. The citation was issued yesterday. It's never been served. We didn't receive 10 days notice of the hearing. We didn't receive any substantive information about what we alleged lack of authority is. It basically does. We haven't been provided with either the time or the fundamental information needed to be able to respond. I don't want to waive that objection, but without waiving that objection, if the court wants to proceed, then it's fine.
Yeah, I understand. You've received the motion. You've not been cited, correct?
No, I have not, but I have not had 10 days notice.
True, but you received the motion well in advance of 10 days.
More than 10 days before that, I had received the motion. We do have some cases that could say it's 10 days notice of the hearing that is required. I provided one of those, I think, to the court.
What case is that? Just so I can put it.
It's shut.
And I do have your notebooks if you provided. I do appreciate that.
I will, let's see, I had it right here, and my phone was always having too much stuff. I can tell you 1 second. Bennett versus Primal Land Capital. That is one of the cases I gave the court. I can give you another copy if you like.
No, I have it.
But specifically, that case says, among other issues with the Rule 12 motion in this case, is that it was not set for hearing and it did not provide 10 days notice of the hearing. The same facts in that case where the motion had been filed, but the notice was not given. 10 days notice of the hearing was not provided. But in that case, I have provided support. And the motion also, not only, there's no 10 days notice of a sworn motion, the motion is required to be sworn. I think 2 or 3 days ago, they filed what they called an affidavit in support of it. The motion was never verified. The affidavit is like, it doesn't meet the requirements of an affidavit, doesn't state that the facts stated in this are within my personal knowledge and are true and correct. It doesn't do that. But more importantly, and substantively, it doesn't state any facts that would support a motion to challenge the court.
Mr. Boyd, you want to respond?
Yes, a couple of responses. The first, with respect to the Bennett case that was cited, there was much more than just problems with notice. In fact, part of the reason that there was no notice of the hearing is because that there was actually no hearing. And furthermore, it wasn't even a Rule 12 motion at all. It was instead a motion to strike that the appellant was encouraging the appellant court to construe as a Rule 12 motion in hindsight. So I'm not really sure that that's apples to apples. And then on the as far as the affidavit goes, the rule does not require swearing to facts. It's based on belief, right? Not factual knowledge. So, swearing to facts when the rule only requires that you state that you have a reason to believe that the attorney is proceeding without authority would be superfluous.
So address for me in Rule 12 where it says sworn written motion. Show me where your motion is sworn.
In my
In your,
the affidavit.
yeah, your emergency Rule 12 motion that was filed on August 29th.
So I filed the affidavit afterwards on. On 9/15/22, I filed with the court an affidavit in support of emergency Rule 11 and 12 motion to show authority after the initial filing.
All right. Did you cause Ms. Vidal to be cited?
I attempted to, but was not able to achieve case.
And do you believe that that satisfies the rule?
Well, unlike other rules that require citation of service, this one is silent on exactly what that process looks like. So, and from examining other successful rules, Rule 12 motions in other courts, I haven't seen what's where there has been a service of personal service. But I did serve for 20.
So you're telling me that you believe that Rule 12 is discretionary from court to court? So,
No, Your Honor, it requires specifically a sworn motion, a verified motion, which this is not. And the notion that you don't have to give facts is odd. He says, I need to say I have reason to believe, but he doesn't state what the reason is. There are no facts to support what those reasons might be. I have not been provided with notice of that. Certainly not in a sworn plea, and certainly not citation. And the problem is citation wasn't issued until I think yesterday. So that's the reason why he hadn't served it. It's just all done on without the required notice, either with respect to time or the fundamental information we would need to respond.
any response?
No, Your Honor, I've made my arguments. I mean, and I agree that this was not as sharp with attempt on this violence. If the court doesn't feel that it has discretion to accept the citation and notice that it is, then we will be happy to correct that. But then that sort of perfects our argument in response to Ms. Vidal's discovery motion, because we're arguing that she had no authority to file this lawsuit. And if she had no authority to file a lawsuit, she certainly didn't have any authority to serve as discovery. So, I mean, among other things, we feel that that's obviously good cause for, which is the only burden that we have to show to overcome her discovery.
So you're saying you don't want to take up the discovery issue until a report determines the Rule 12.
Exactly.
So that I'm gonna sustain your objection. Court's gonna find that this emergency Rule 12 motion was not sworn. Court's gonna find that it was not served upon Ms. Vidal, and that Ms. Vidal has not had the appropriate time as provided under the rule to prepare for the motion. So I'm gonna sustain that objection. We're gonna go forward on your motion for discovery.
Thank you. May I proceed with my discovery motion?
Yes, ma'am.
Your Honor, we served discovery requests in June. Shortly after the temporary injunction hearing that we had before Your Honor. The discovery requests I have attached a copy of to the motion, and I have a copy if the court doesn't have one with it, but it's in the notebook behind tab 1. And the discovery requests are the only attachment. There were no responses to any of the discovery requests at all for an extended period of time. Then I think sometime in August, Mr. McCoy said, I realize I've not answered requests for admissions. And he said, and I'm trying to pull together documents, and I'll get documents to you, and I'll get you these other responses. I received nothing, none of the responses he said I would receive, not to the document requests and not to the interrogatories. He did untimely respond to some, not all, of the requests for admissions. The requests for admissions and the interrogatories were interrelated. So, for example, one of the documents that we're asking the court to hold unenforceable in this case is a 30-year lease. And very simply, the lease says Happy Hollow Ranch Limited Partnership leases the property as described on Exhibit A. Well, there is no Exhibit A at all, none, at least not on the copy I have. So I sent for a request for admission to opposing counsel and said, admit, there is no Exhibit A. Very simple request. That's the kind of thing we shouldn't be fighting over, and I ought to have a simple answer. I got no answer. They didn't answer that at all. Then he sends me a denial. The problem with that is I followed up with an interrogatory, which said, if you did not admit that request, admit that there is no Exhibit A, unequivocally, then describe the property. Tell me what the exhibit is and tell me what the property description is. And I got nothing back for until I guess this week, or maybe last week. There were no written responses to the interrogatories at all, none, until I filed my motion that is presently being heard by the court. A day or two after that, he filed objections to the interrogatories, including the one that said, tell me, what's the property description? What property was it that was being leased? Nothing but objections. The document requests followed up behind that and said, give me Exhibit A. Very simple. He did produce documents. I can't find any Exhibit A. He just says, instead of doing what he's supposed to do, and that is either respond by saying it's document number 4582, whatever it is with the base number, or here it is, here's Exhibit A attached to my request. He didn't do any of that. He said, well, I produced anything I could find. So I don't know if there even are any records. If there is an Exhibit A, he's denied it, but he won't tell me what the description is, and he won't produce documents. I believe his objections were long ago waived to the interrogatories and to the request for productions. The Rule 193.6, of course, says that if there is a failure to respond to discovery, anybody who does not respond at all or who does not timely respond may not introduce evidence that was being requested in the discovery unless they can show good cause. You know, in August, when Minister McCoy said, I'm doing this, I was expecting to receive this, and I would not have filed a motion to compel. I kept expecting to get it. And what I've gotten around is a runaround, just exactly what you're hearing. Every time I would talk with him or email with him, he would say, well, we'll do it after we hear the motion to show authority. We'll do it after we determine you're allowed to proceed with this case. As if discovery is contingent upon him losing of his defenses. And so, which is basically what he's asserting. So this is not an inadvertent. It may have been initially inadvertent, but this is not an inadvertent failure. This is an intentional refusal to respond. Mr. McCoy just told you, I shouldn't even have to respond to the motion to compel, or motion for sanctions on this, when there hasn't been a ruling on my motion to show authority. He just doesn't, he thinks he can thumb his nose at a discovery request. And there is no provision in the rules that I am aware of, and I've been doing this for 40 years, it says you do not have to respond to discovery if there is a Rule 12 challenge, or if there's some other challenge to the lawyer's authority. To the contrary, I believe that the rules are designed to facilitate settlement, facilitate the exchange of information so that everybody knows what's going on. I've tried to do that. Mr. McCoy has never sent me a discovery request. I sent him documents without a request. I sent him a whole boatload of documents before he ever sent me a piece of paper, but I can't get any kind of response. And the rules don't require me to get zero response. Their objections are waived. Then when I file the motion, that he files his objections for the first time, Rule 193.6 does not permit that. It says a failure to respond means there's no evidence going in on that issue that you didn't respond on. It's different than a sanction. I know the sanctions, normally you have to do the least, the least severe sanction, and you work your way up. Rule 193.6 is exempt from that. That's not included in that. That's not a sanction. It is the thing they put in the rules that's supposed to make lawyers at least try something. Because if not, I'm coming in and saying their responses were inadequate, they didn't respond. And when they did respond, as I said, I got nothing but objections except for one. Interrogatory number 2, they actually did say something, but it's not verified. And a non-verified interrogatory answer is the same thing as no interrogatory answer at all. And it's not, again, facts, it's mostly lawyer opinion, but if somebody wants to swear to that, fine, they didn't. Nothing is sworn to. Documents, when they produce them, they're mostly illegible, difficult to tell, they're not unitized correctly. It's just, you can't tell where one document ends or another begins, and sometimes they're not even in order. So I have a really hard time sifting through this where I'm trying to find Exhibit A, and I can't. And I know, Your Honor, I don't like discovery motions. I'm the last person. I don't usually show up in a courtroom on a discovery motion of any sort. I try to give up all my stuff, and I don't fight about it if I can get substantive answers. But what's going on here is intentional, and I need to break past that. And I think Rule 193.6 is specifically designed for that. So I'm asking the court, I have a proposed order to order that All right, you don't have to respond to, your objections are waived. You don't have to respond to those interrogatories because your request for admissions, you admitted the request for admissions and, you don't have to respond to those documents requests. The request for admission, for example, says there is no exhibit A. Whoops, that's another, that's not the word, I apologize. And, but then there were some document requests that were not contingent on the interrogatories, and I am asking for an order compelling production of those documents. And I will have the proposed order for you here in just a second. I don't know what I did. There. I know we filed it and I know I had it. I just don't know what I did. I don't know what I did. Your Honor, I'm sorry. I did file the order and I can provide that to you.
Okay. Mr. Boyd, you want to respond?
Yes, Your Honor, a couple things first. So, with regards to the exhibit A, as far as the merits of the issue, right? Exhibit A in that document is redundant because it immediately follows the address. So, it's the description is still there. The exhibit A was considered as a redundancy in the document. And there is indeed an exhibit A attached to the document, it's just blank. And so we both have the same document sheet actually produce that exact document with the blank exhibit A in it. So, and Brandon's.
But did you respond to her discovery request saying that?
Yes, all, in our opinion, all of our discovery responses have, we responded to everything. And we are trying to supplement those responses with something, we have probably over 2,000 pages of discovery. Brandon initially brought us to work on like second week of August, I believe. And at which time started scanning and got them scanned in as quickly as possible, stamped, and then sent them to Ms. Vidal so that we could get her stomach. And then I explained to Brandon that scanned documents are not sufficient, that we're going to have to actually sit down and go through and, you know, preserve the native format of emails and digital recordings and all that stuff. So I think it was week before last.
Yeah.
Came to my office and we spent the better part of the day gathering all this stuff. And then prior to this, the reason that August was the start date is that you know, Brandon, when he the TRO was issued against him, that his work on the ranch was suspended. So he was left in a situation having a pregnant wife, 2 kids, and a third on the way. That was, and the third was born July 1st. And her name? Merritt. And Merritt was born with some she was very in the front. Yeah. Some health issues. And they are still continuing to deal with these health issues. Brandon's, so he's got his job and sick kid, and he's also trying to develop his education at the same time. On top of that, with the professional circumstances, for the first probably 2 or 3 weeks after close to a month between June and July, Brandon was not even sure that he wanted to, or that have the means to be able to try to defend us and the way that it was tried, just for obvious reasons. So you know, all these things have come together to, Your Honor, we're doing everything we can to get a mountain of documents. He has tons and tons of evidence to produce, to show that he will prevail on this fight. And we just have it in organizing them and making them responsive and organized by Mr. Ball wants it takes some time. And I assure the court that we are working as diligently as possible to get that done. And aside from it, as I mentioned earlier, contrary to what Ms. Vidal alleges of power, no grounds for not producing seven. I'm not trying to say that I understand that it would be a risk and ill-advised to stand on solely the basis that we don't think that she has authority, so that we're not producing discovery. That is a secondary argument to supplement the primary I've just provided you. But to be sure, if we do come in here and show authority or show that she does not have authority, her pleadings are struck, her failure to show authority reverts back to the date of the filing. So the subsequent discovery request would be just as invalid as the petition.
But there would be no harm in doing that, as we're telling you. If she's shown to have no authority for producing discovery, not.
It would be a non-issue, exactly. And probably the most important thing is that I believe that Ms. Vidal, to sustain what she's asking for, requires some sort of prejudice to be shown, and I don't know about how our discovery is question points and prejudice.
Well, tell me this, I hear Mr. Vidal saying, I say I hear, this is what she said, that she doesn't want to come in and argue motions for discovery, wants to give them out, doesn't want to deal with that, wants to rely on transparency and the facilitation of settlement, those things. If she were to toe that line still in this case and not ask the court to compel you to produce your discovery, when is it that you can produce all of your discovery by a time, date certain, so that this would all would have some kind of assurance as to when that's going to be produced, and if that deadline's not met, then she can come back in here and re-urge her motion.
Understood. And to be sure, all of our discovery is Brandon has no intentions of, he wants all parts on the table. We produce everything that we have now. The time that it will take to get it in the organized format that Ms. Vidal wants, I'd ask for a couple weeks.
And Ms. Vidal, are you saying that you believe that there's still discovery that they're withholding and not producing?
I don't have interrogatory answers. I one answer he gave me was not verified. I didn't hear any reason why he couldn't do that. And I would like to address the prejudice issue. Rule 193.6 said the reason for this is in fact to facilitate discovery, so people can know what the facts are. We've already been to mediation, that's over. And we didn't have any documents, we didn't have any discovery responses, and mediation was scheduled after all those responses were due. There is a prejudice. I would like to file a motion for summary judgment in this case. I think the statute of frauds is going to dispose of most of those contracts, even without getting into the capacity issue. But I can't do it with these discovery issues pending. If I file a motion for summary judgment and say there's no exhibit A, and then he says, oh, here's exhibit A, you didn't ask, or I have these objections. That's the prejudice. If I would have, if I had answers, I would have had that motion filed a month ago. So 2 weeks, I've got to give them 21 days notice on the motion, and that's way too much. It does prejudice us.
Your Honor, like I said, there is no, the only documents that we have not yet produced are ones that have come to my hand in the last 3 or 4 days, and that's not. We produced every document that we have. I can have the interrogatories cured, likely by the end of the day, or certainly by the end of tomorrow.
Mr. Dahl, tell me, so you're wanting me to compel Mr. Howley?
The order that I have here somewhere, and for some reason I'm not finding, says orders that they are not required to respond to and may not respond to interrogatories, the interrogatories, because they failed to respond until the day after I filed the motion, and then I think they filed some of the objections, but they may not respond because the request for admission said, the interrogatories literally said, only if you did not admit this request, then respond. And since the requests are admitted, they really don't need to respond. But there are 7 interrogatories, I think it's 7 through 21, the last part, not interrogatories, request for production, that are not contingent on the interrogatories. That's what we're asking for. If the court is not inclined to do that, then we would like to compel answers to the full set of interrogatories, complete answers, and complete responses to request for production, certainly within the next 5 days. I mean, they've had these since June. I can't imagine. They've had them since June. We were set for trial. We've been set for trial twice, and they haven't been able to respond to a document request or an interrogatory. I said 4 interrogatories. We're not talking about a lot of interrogatories. 4. That's it.
Anything other than the interrogatories?
The request for production of documents. Same thing. Now, the request for admissions, as I understand the rule, they are deemed admitted. So I'm not asking for anything additional on that.
Your Honor, we have a motion before the court that you allow that we filed sometime ago to allow the untimely admissions to not be admitted, and ask that you grant us that motion going forward. Further, Your Honor, I'd like to point out the fact that this case has been set on an expedited basis that doesn't really meet the expedited basis of what the rules of civil procedure allow. And so that, to the extent that there's other reasons for delay. And we also argue that the urgency that posture that this case was brought in has since dissipated with the apparent imminent withdrawal of the solar company and the vigilance with which they continue to pursue the project. So the time constraints that we will once again no longer seem to be that issue.
Well, I won't take up the court's time too much, but no, first, his motion, which is not a motion to undeem admissions, it's something different. It's not set today. I haven't received any notice of it, nor did he ask for it to be set. The claim that the time was not within the rules of civil procedure, either for the trials or for the discovery, is just not correct. The rules of civil procedure do specifically allow for accelerated trials. They do specifically allow in those cases where the court can reduce the time to respond to discovery. We did not ask for that. We gave them the full amount of time. I thought about asking for that. but we gave them the full amount of time. And apparently, and they just ignored us. I mean, they just, their view has been to me, you don't have authority, so we're not responding.
All right, so I'm going to grant your motion to compel. I'm going to order Mr. Howley, Brandon Howley, in Lownjager to comply with the court's order by completing full responses to the interrogatories within 5 days. So today is the 21st. So that's going to be due to Ms. Vidal before close of business on the 26th. That's Monday. As well as the request for documents within the same time frame, and also the request for admissions. And I'll allow you, Ms. Vidal, later to come back and re-urge to the court why the court should find those to be deemed admitted. But I want him to go ahead and respond to your request for admissions.
Okay, just so that I'm clear on procedure, as I understand the rules, deemed admission is sufficient summary judgment evidence. I'm going to file a motion for summary judgment. The rules, I believe the rule says it is deemed admitted if it is not timely answered. Until it is, so I understand he's going to answer, and that's great. I'll just address all of that, I guess, in my motion.
Yes, and that's
Okay.
what that's.
Yeah.
Your Honor, so I had submitted my motion to allow on time admissions. With the request that it be answered on submission if the court will set a hearing what wants to hear it. And in my experience, that's typically something that that could be heard by submission, but if that's what the court wants to, and this would all wants to have a hearing on.
Okay, for the time being, I want you to respond to the discovery interrogatories, admissions, and the.
Certainly.
And then I'm interested to see what the admissions are after the fact, and that obviously you can argue that in your motion for summary judgment, or if we want to come back and have a separate hearing on whether they should be allowed. But to kind of move the ball down the field, that's what we're going to do at this time. Ms. Vidal, understanding that the court has granted and sustained your objection to the Rule 12, is there anything that you want to put on the record that you believe would stave off an additional filing by Mr. Brandon Howley and Lownjager regarding the new Rule 12? And I understand that I'm not asking you to have a full-blown hearing on showing your authority, but is there anything that, I mean, you provided some information to the court, you want to put any of
You
that?
submitted, yes, let me go ahead and submit. We filed already, Your Honor, the affidavit of Robin Howley. And I guess I'd submit that it shows that she has, as the trustee of, as a manager of Happy Hollow Ranch Limited Partnership, and as a trustee of the Howley Family Trust and the 2 spousal trusts, she did retain me to file this lawsuit along with her brothers. One of the things she does do is she explains that, and I think I've had some discussions with Mr. Elliott about this, and he might want to say something on this. We have Scott Howley has resigned as the next friend and as trustee of all of the trusts. Well, he was in the process of doing that. The documents have been drafted during the process of getting signed. So that the case will not be going forward with him. This Robin Howley testifies in her affidavit that he did that because he thought it would be in the best interest of his parents. He during early 2020, he advocated for his son, Scott, for his son Brendan, and that will probably not be helpful to his parents. So the fact that he advocated back then, I do not believe is a conflict of interest today. Because he thinks that's one of the biggest mistakes he's ever made in his life, and he regrets it, and he is not an advocate for Brandon today. But he did advocate for Brandon in early 2020. And because of that seeming conflict, he is willing to, and has offered, volunteered to resign all of those positions. So the case will not be going forward with him at all. It will be going forward with Robin. In addition, I spoke with Mr. Elliott, and I think that Mr. Elliott was happy with that event. And also, we discussed adding in where Scott would have been a corporate trustee. And so that the trustees will now be Robin and the corporate trustee. We are in the process of trying to do that. It isn't the easiest thing in the world to call a trustee and say, we would like you to jump in the middle of a loss. They're asking some questions and they're looking at it, but I think we're going to be able to get a corporate trustee too. So we'll have both Robin and corporate trustee. Proceeding. So that's it. I don't think that the Rule 12 motion should have been filed, so it's kind of hard to figure out how to stave it off, but I hope that assists.
Thank you, Mr. Bell. Mr. Elliott, do you want to just report on that issue at all?
Yes, Your Honor. When I was first appointed this case, I had met with both attorneys. Began with Mr. Coy, and I had an opportunity to look at evidence, and I did believe that there was an appearance that there was, at least for Scott, a conflict whether Scott was acting in the best interest of Chuck and Nancy, or if he was acting in the best interest of either Brandon or the whole family, as opposed to Chuck and Nancy. I've expressed that to both attorneys. There are some questions, or at least I have some questions, or had some questions, as to whether Scott's conflict, being that he filed with his sister Robin, whether those would essentially be her conflicts also. I have expressed this with Mr. Dahl, and the complication in all this is the Happy Hollow LP is jointly owned by the two trusts, and there's a third family trust, so it does get a little complicated. Those two trusts right now are going to be having joint trustees that cannot act. Either one of them can act in their own capacity. So even we discussed the potential of Argent Trust, which I am familiar with, and do have ongoing communications with them on other cases. Stepping in and being one of the co-trustees. And I do believe that Argent's obviously going to be doing what is in the best interest of the trust, pursuant to the trust documents. In addition to that, I went and looked at the original trusts that were signed, I believe in 2004 and 2011 by both Chuck and Nancy. And there are provisions within the trust that ultimately the successor trustees would have been Scott and Robin. And there are provisions within the original trust document that contemplates an appearance of self-dealing, and it waives liability for that. However, for the purpose of this lawsuit, Mr. Dahl has done what we have discussed, or is in the process of doing. Scott has removed himself. And I do believe there's evidence that would make it apparent to the court and any third party that there would at least have been, if not still is, a conflict between Scott and Chuck and Nancy. I believe that the actions that Mr. Dahl is putting into place would relieve that conflict. With regard to Chuck and Nancy in their individual capacity, which is the only reason that I'm here, In addition to this, as far as the Rule 12 and the authority, if there's not a conflict with Robin, and especially since there's a co-trustee that's going to be in place that is a corporate trustee, I don't believe that that's going to be an issue. Now, I believe that that issue will be resolved. As far as the trust is concerned, I don't have any authority to argue on behalf of the business anyway. So my concern would be, if for some reason this is all were conflicted out, there has been no issue presented to the court that would change the successor trustees that are now in place. There could be, if somebody wanted to present those, but this time I don't think there's anything that's been presented to this court or any other court, to my knowledge, that would have removed Scott or Robin, and I've reviewed the documents, as successor trustees. And now that Scott is removing himself, not only as the next friend, but he's also removing himself as a successor trustee, I believe that that would resolve the conflict between Scott. It removes him from the equation completely. Ms. Vidal has agreed and is not objecting or even attempting to have me removed as the ad litem. And I believe that that would be in Chuck and Nancy's best interest, because at this point in time, there are some pleadings that I did agree to sign on with the, I believe the second amended.
Well, it's now the third, because
Third.
if something happens, I'm gonna go into
Okay,
that.
it's the third amendment that we discussed yesterday. I am only filing them in their individual capacity. As far as Ms. Vidal's authority or whoever's authority to represent the corporation or the limited partnership, I don't believe that that issue is the same as the next friend issue. But again, that's an issue that would have to be taken up under the Rule 12, that I talked to Ms. McCoy about this morning, and she's gonna have, I'm assuming gonna have an opportunity to have that heard at some point.
All right, so clarify that for me again, because I was going to ask you, do you believe that Ms. Vidal has capacity or had capacity to bring this suit on behalf of Chuck Haynes?
As individuals, I believe that there was, as far as the authority as individuals, I believe that with Scott, I don't necessarily believe that it was an issue for Mrs. Vidal. I do believe that there was an issue with Scott truly acting in the best interest of Chuck and Nancy. I don't.
Well, and let me intervene here, and I believe that Ms. Vidal has addressed this in some of her filings. She's pointing out that the conflict may exist between Scott and Robin and their interests, but it does not affect her ability to have the authority to have been hired by them to bring this. So her argument is that the only issue is not an issue of authority and conflict for Ms. Vidal as attorney under Rule 12, but whether or not there existed a conflict between Scott and Robin, which is the purpose that you're here today, because the court's already found that there was some appearance that there was a conflict, potential conflict or a conflict of interest between what Scott and Robin's actions were and whether or not they were in the best interest of, as next friends of Chuck.
So in that regard, I believe I haven't seen anything that would present a conflict for her representing Happy Hollow LP in any form or fashion. I'm not even sure if there's been any pleadings to that effect that may be addressed in the Rule 12. But with regard to the conflict of her ability to represent Scott and Robin, I don't believe the conflict. And at this point, I truly, and again, this is just my opinion. And I know Mr. McCoy is going to have a different opinion on this. I don't believe, and even some of the text messages that I read, I don't believe at this point I'm seeing any evidence that would indicate that Robin knew about the communications back in 2000. And then I certainly don't believe that Ms. Vidal had any knowledge of that when she was filing this, or at least I haven't seen any evidence to indicate that. So I don't believe that there would be a conflict. And I certainly don't believe there's a conflict for her representing the partnership at this time.
All right, thank you, Mr. Boyd. If you want to touch on that, you're welcome to. You don't have to.
I do.
Okay, good.
So we've got Nancy signing contracts and which the law presumes she did with capacity and without reviewing. That's where we start. And we've got Happy Hollow, Robin seeking to undo those contracts, which the court must assume from on its face was what reflected the intentions of Jack and Nancy. So I do not see how there's any conflict there. As long as that's the issue and we don't have definitive proof as to whether Nancy had capacity or was subjected to undue influence, there's the appearance of a conflict. Is on this issue.
Thank you, Mr. Porter. Anything further, Mr. Ball? I'm not asking, I'm just giving you the opportunity.
Yeah, I'm not sure I understood that, but no, thank you, Your Honor.
Mr. Beckham, you're welcome to chime in if you want to on the opportunity. If not, we can talk about just some housekeeping. It looks like our next scheduled hearing is the 26th, October 26th. Is that correct? And that's on your motion to dismiss. Is that right?
Yes, Your Honor, it's my understanding that Scott has removed himself as a plaintiff in this matter, but he still is an individual. That's my motion to discuss.
Okay. And then it looks like we have, we're still set for bench trial beginning November 30th and then going to December 2nd. Anybody seeing any kind of scheduling conflicts or issues with that, or does that look like that's something we'll be able to make happen?
What was the next hearing? The
26, October 26 on Mr. Beckham's motion to dismiss. And on the bench trial date, I believe the check my calendar real quick. I believe that it's two separate days. It's not the 30th, the 1st, and the 2nd. I believe it's just the,
Yeah, they're not consecutive.
they're not consecutive.
I-
That's a better way to say it. Okay. All right, so Mr. Dole, you are going to either find that order you were trying to find earlier. for me,
Yes.
Or you're gonna prepare me another order on the motion to compel, or with the order.
Yes, I have to write it a little bit differently anyway, because I think you are ordering different. My understand, so
Correct, correct, and that'd be closed to business by Monday,
26.
26th. Okay. Anyone have any questions or any other issues we need to take up?
Your Honor, we know where will be the next hearing.
The next hearing, let me see. I can probably figure it. October 26th. We should be here. We should be here.
Thank you.
Well, that could just mean that grand jury is that day. It's either gonna be here or we may have to pile into a conference room over in the north annex. Much smaller space, but we're a little bit, we're still nomadic. All right, if there's nothing further, then we'll be adjourned and Mr. Dahl, give me those orders, and I'll get those signed and emailed.
Will do, Your Honor.